Would you ask Mr. Todd to come back in, please? Right, Mr. Todd. All ready to carry on?
Oh, yes, sir.
Good, thank you very much. Yes, Mr. Beryl?
Yes, Mr. Chairman, thank you. Mr. Todd, I want to ask you some questions now arising out of your witness statement, and particularly in relation to the LGA guide. If I may.
Oh, yes, sir. Thank you.
Yes. Now, can we go to your witness statement, please? At CTA 6012, we looked at it at the very start of your evidence formally.
I recall, sir, yes.
Yes, and at page 15, can we look at paragraph 71? And at 71, you say, and this is in the context of the consultation on the draft LGA guide.
Yes.
That in the second line, in addition to providing detailed comments on specific clauses of the draft, we asked 7 overarching questions under 5 headings as follows.
Yes.
And on page 16, you see question 6 under the heading of diversity.
Yes.
And the question was, do you think that the guidance deals adequately with vulnerable people, such as people with disabilities who need assistance with evacuation in the event of a fire?
Yes, sir.
And then you go on to say in your statement at paragraph 75, if you could please go to that on page 17, you say, in this connection, only around 50% of the respondents addressed the question on vulnerable occupants. A number of these were seeking only clarification of responsibilities. Others highlighted the importance of compartmentation for the safety of disabled people, so enabling them to stay put in the event of fire. In terms of the definitive question as to whether or not the question of disability was adequately covered, respondents were almost equally split in the affirmative and the negative.
That's correct, sir.
Yes. Now, Did any responses identify the problems that could face a disabled resident seeking to evacuate a fire or evacuate from a fire in their own flat or on their own floor?
In their own flat or their own floor, I'm not sure whether they did or not. A number of respondents talked about the need for assistance to disabled people. A number of respondents said the guidance was fine. I think one complained that the fire authority were asking for assistance to be provided by the RP for evacuation of disabled people, or PEEPs to be prepared. PEEPs to be prepared it was. It was a bit of a curate's egg of response, is the nutshell answer, sir.
Now, let's go to HOM 402660 at page 7. This is the response from the Chief Fire Officers Association.
Oh, yes.
And it answers your question 6 under diversity as follows. The document, as stated earlier, tends to avoid any reflection on the effect of occupancy on the adequacy of provision over and above, stating the minimum required for building regulation or benchmark compliance. Experience shows us that the stay put policy is adopted in many situations to overcome difficulties with disabled evacuation, with the building failing to meet the standards required for stay put. Many providers have taken great effort to provide access for disabled persons and fail to appreciate the difficulties in a fire situation when the measures they've provided cannot be used in a fire situation. Additionally, the document states that where fire may start in common areas, then occupants in these areas should make their way out of the building. To ignore and eliminate advice on disabled access and evacuation is a fundamental error of the document and is recommended that it must be included.
Yes, sir.
Now, in particular, focusing on that last sentence, how did you respond to that view?
Well, that was one of the, I mentioned somewhere in the affirmative, somewhere in the negative. That obviously falls into the category of in the negative. Others expressed a completely different view. One particular fire and rescue authority said there is no need for you to give any consideration, further consideration to disabled people because it's adequately covered in other documents.
Now, in considering the answers, did you, or rather, in asking the questions, did you seek the views of organisations representing disabled persons?
Not as I recall, sir. I'm not sure if LGID might have done, but I don't think we as a practice particularly did.
Why was that?
Probably because we were focusing on the fire and housing sectors, and it may not have even occurred to us, if I'm honest.
I was going to ask you, did you actually think about it?
We thought about disabled evacuation. I think I produced a document for you, sir, that showed within 2 days of being awarded the contract, we had a list of showstoppers, if you like, that we wanted to address, and one was disabled evacuation, and I think we said evacuation or not in our note, internal note on that, and then we wanted to get the public view on this. So this consultation was open to everyone. We invited through certainly fire journals and through the profession contact from our consultation from as wide an audience as possible. We put on 3 public roadshows, but LGID did the invitations to those, so I'm not sure who they invited and who they didn't, sir.
Right. Can we then look at HOM 45964, the guide itself, the LGA guide itself, at page
Yes,
120? And I just want to show you 2 paragraphs in there.
Yes.
At page 120, you will see 79.9 at the top of your screen. And it says this: in general needs blocks of flats, it can equally be expected that a resident's physical and mental ability will vary. It is usually unrealistic to expect landlords and other responsible persons to plan for this or to have in place special arrangements such as personal emergency evacuation plans.
Yes.
Such plans rely on the presence of staff or others available to assist the person to escape in fire.
Yes.
Now, I just want to ask you about the process whereby those statements came to be included in this guide. First, do you remember that you were separately made aware that in September 2011 it had been suggested to a gentleman called Sir Merrick Cockell, late I think at that time of RBKC, but then of the LGA, that the guidance in respect of dealing with disabled persons was unlawful, and you were tasked by him with providing a response? Do you remember that?
This was after it was published, was it?
Well, it's September 2011.
So it would be after it's published. I don't recall that off the top of my head, sir. No.
Well, let me see if I can help.
Okay,
can we go to HOM 30's 19844? This is a letter from an organisation called Triple Consult
Oh, yes.
to Sir Merrick Cockell, who was chairman of the LGA. And if you scroll down to the end of the letter at page 4, you can see that it comes from somebody called Elspeth Grant.
Yes, I know Elspeth Grant.
Who was a director, yes. Are you familiar with this letter?
It doesn't ring a bell with me,
Right.
But it may well have been shown to us, sir.
Okay. It's a long letter. I'm not going to read it all to you, but the gist of it is that 79.9 that I've read to you,
Yes.
and also 79.11 that I haven't, but I think you're familiar with,
Yes.
which says it's not realistic to expect such an approach
Yes.
to be adopted where disabled persons require assistance in a general needs block. The complaint, if we go to page 2 at the top of the letter, says, I'll show it to you, these clauses reflect, do you see?
Yes.
These clauses reflect an outdated viewpoint which is highly discriminative and not in line with UK legislation relating to equality or fire safety.
Yes.
Furthermore, the wording is directly contrary to the legal advice given in Department of Communities and Local Government's Fire Risk Assessment for Sleeping Accommodation and the Supplementary Guide, Means of Escape for Disabled People, Lake-Hawes Housing, Fire Safety Guidance and BS 999 2008. If this guidance is not amended, the LGG is also at risk of legal action as a result of publishing advice that's contrary to the law. And there's some relevant legal background set out under that.
Yes.
And then it goes on in a similar vein. And the conclusion at the end, on page 4, is as follows. If this guidance is not amended, building managers and landlords who follow this advice will continue to discriminate in the area of fire safety against disabled people, who represent 1/5 of the population, and indeed will be open to criminal or civil prosecution. Given the current approach to disabled evacuation and lack of enforcement in this area, it is a little surprise that the Fire and Rescue Service Equality and Diversity Strategy states the impact of fire is grossly disproportionate on some communities. For example, 39% of fatal fire deaths are people with disabilities.
Yes.
I hope this letter has explained the issues and look forward to your response before the guidance leads to an unnecessary tragedy because plans were not in force.
Yes.
Now, having read that conclusion to you in its quite stark terms, does that ring a bell with you?
It doesn't, but it may well be. I would have thought LGID probably would have sent it to us for comment, or to CLG. To be honest, it was sent to LGA, was it?
Well, it was sent to Merrick Cockell as yes, exactly. As part of the LGG.
I would have thought they would have sent it to us and CLG at the time. So I would think it's quite likely that this would have been sent to us.
Well, I think we'll see this probably from the next document. Can we go to CLG 100040907? Because this is an email. Help me with it. I think it shows that your practice was sent this email, this letter. If we go to the second email down on the page, it's a letter from the CSTA office. That's you.
Oh, yes.
Caroline Bosdet. Is it Bosdet?
I think so, yes.
Yeah. Copy to Louise Upton and Brian Martin.
Yes.
Dear Caroline, please find attached the basis of a response to this person's letter. You may feel it's a bit on the long side, but you know what we're like.
Oh, yes, so we did see it.
You did see it. And if you then go...
I don't know that I was... whether I saw the response. I probably did, but...
well, I'm so sorry. Partly my fault, actually. Can I go to page 2? Because I think we could. That's the response.
Okay.
From Stephen Dawes. The email that comes from Caroline Bosdet is on the top of the next page, 29th of August 2011, to you. To your office. And she says, hello, Colin. I'm not sure this organisation took part in the consultation, but it would be good to check if there was a written response from them. Sir Merrick Cockell is the new chairman of LG Group, our equivalent of the minister. I'm currently off after a knee operation and can't log in properly, hence forward the emails. Hope the letter's attached. Are you able to provide a response to her points, as I'll be expected to provide a full response on this? I've also copied in GLG colleagues who also will be able to provide views. Many thanks, Caroline. Okay. It looks like you got it.
Yes, it looks like it.
We've seen Stephen Dawes' response to that. Was the response by CS Todd a joint effort by your practice?
I honestly don't know because I don't recall the letter. What I can see, can you go back to the reference, sir?
Go back to the reference.
Yeah, down the bottom of the bit about, what we're like.
Yes, go to page 1. Go to page 1, second email down.
Right.
Dear
so you see the reference there, sir? So SD means the letter was generated by Stephen Dawes, and MH means that it was peer-reviewed by Malcolm Hoare.
Yes.
But it may well be, and I certainly don't devolve myself of responsibility, it may well be they ran it by me, but it looks as though it was dealt with by Stephen.
Right. Well, my next question was, did you have any hand in drafting?
Yeah, that's what I don't know. I can probably find out.
Well, let me show you the draft response.
Yes, okay.
Because I don't want you to go and find out. I want us to do this together.
Yes, of course.
Here. CLG 100040906. And you could see it's clearly a draft. And we will come to see that it's, in fact, just so you understand, it's significantly different from the version that's finally sent.
Okay.
And just for our reference, that is at CLG 100040932. But if we look at page 1 and look a little lower down on the screen, if you go to the 5th paragraph down...
Would you mind if I just read the paragraphs before it?
Of course, please do.
Thank you.
And tell me when you got to the 5th paragraph down.
Of course. Yeah, so I certainly agree with the first 4 paragraphs. Whether I saw it or not, I agree with what's in the first 4.
Right.
I'm now at paragraph 5, sir.
Thank you. And it starts, we would agree with your view that the FSO applies to purpose-built blocks of flats.
Yes.
And there is an obligation on the responsible person to carry out a fire risk assessment. Indeed, one of the main purposes of the guide is to explain in detail the application of the FSO to purpose-built blocks of flats and to guide readers on the process of carrying out a fire risk assessment. You will find this in parts C and D of the guide. However, as I'm sure you are aware, the FSO only applies to the common parts of blocks of flats and not the individual flats, which are domestic premises. Therefore, the safety of residents in their own flats is clearly outside the scope of the FSO. Do you remember seeing that and approving that statement there?
I don't remember, but as I say, it may well be that I was. I don't know why Stephen did the reply. That's what's
Right.
slightly confusing me as to whether I wasn't available or whether, because he led the drafting team, I gave it to him. But if I was around, I'm sure I would have looked at this.
Was it the view of your practice at the time that the FSO did not apply to the evacuation of disabled persons from their flats?
I think our view was if they had a fire in their own flat, that was outside the scope of the fire safety order. And as we've discussed, sir, that's by far the most likely place for them to have a fire or to be affected by a fire.
Yes, and we covered that a little bit earlier in your evidence.
Yes.
As at the date of this exercise, so this is September 2011, did your practice consider whether there were any duties owed to a disabled person once they were in the parts used in common in a high-rise residential block?
I'm not sure that we would have thought of it in these terms. I think you're aware from other evidence that I've given you, sir, that we identified the fact that there was no consistency in the views expressed to us in consultation, and so we took the matter to the project group for a decision as to what they wanted us to say.
Yes, and we'll come to that in a moment.
Of course.
But I'm just interested in the views of your practice at the time.
At the time, I don't really recall it with any clarity as to
Right.
whether we had sat down and actually said what happens when a person goes into the common parts.
You see, a person in the common parts is a relevant person.
Yes?
And that would include a disabled resident.
Yes?
A disabled relevant person, wouldn't it?
Yes, indeed.
And therefore, my question really is, did your practice consider whether there were any duties owed by the responsible person under the FSO to a disabled person standing in what you call the common parts?
Common parts. I would honestly answer that question candidly if I knew the answer to it, but here we are 10 years later. I've no idea really what our...
Now, if we go to page 2, please, of this letter, and look at the second last paragraph.
Did you need me to read the bits in between at all?
I don't think I do, but if you want
don't?
to, we can. It's
Well,
quite
I'd
long.
rather, if you don't mind,
No, of course.
for context.
I'm not going to read it out aloud if you don't mind.
No.
Tell me when you've read the second page. If we can turn to the second page.
Can we go back to where 5 was again?
Yes.
Because that's where I left off. Thank you.
Well, then tell me when you've reached the bottom of page 1.
Okay. Yes, could you turn the page, please, sir? If I did read it, I missed a typo on rationale, but
Well, it was a draft, and as I say,
Yeah.
not the version that was sent.
right. I'm continuing to read. Where do I alert you as to?
At the bottom of page 2.
Okay, I'm not there yet. Yes, I'm at the bottom of page 2 now, sir.
Yes, thank you. If you'd like to read on to page 3, we can, but we'll do that together. In the penultimate paragraph on page 2, you see it says this: "You will appreciate that in the vast majority of blocks of flats, no one is employed to be present to perform any form of assistance to residents in the normal use of the building, let alone in emergencies. We therefore can see little value in preparing PEEPs when no one is available to implement them. We are sympathetic to the suggestion which you and others have made about holding information on vulnerable and disabled people that can be accessed by the Fire and Rescue Service. While we are aware of organisations that have put this in place," then turn the page, "we do not consider it reasonable and practical to recommend that this is adopted by way of default in all blocks of flats. It would place a significant burden on those managing blocks of flats to continuously update the information. Indeed, we have emphasised that inaccurate information might be more harmful than no information." Now, what I've just read aloud to you, was that the view of your practice at the time?
Yes, I think that's probably a fair comment.
On what basis did your practice arrive at that view?
Reasonable practicability, sir.
Was that as a result of some sort of research or some sort of empirical data collection?
Consultation with the housing sector, sir, and the fire sector. And this was quite an extensive consultation. Right.
So did members of that sector tell you about the burdens of those on those managing blocks of flats?
In no uncertain terms.
Right. And did your practice interrogate them about that, or did you just take that at face value?
Well, we realised that this was no different from the situation over the past half century, and that the quirk of blocks of flats coming within the scope of the fire safety order wasn't to actually change the status quo. It was for the purpose of rationalisation of fire safety legislation, and the purpose of including blocks of flats was their possible consideration as a workplace, or that Europe might possibly consider them to be a workplace. So it wasn't terribly surprising that the housing sector, or certainly many people in the housing sector, said, well, we don't have staff and we can't arrange for people to assist with evacuation of disabled people, as you do in all other premises. And so there was nothing, as we saw it, untoward or surprising about the reaction of many people to the whole subject. But as I say, we then took it to the project group and said, there is this contention. I think I've shown you a document, sir, as an attachment to the witness statement, in which we had a list of contentious issues, in which we said, you will need to decide on this because views are mixed.
Yes, indeed. But was the real driver here not the precise legal scope of the FSO, but the practicabilities, namely the undesirability of imposing on landlords or those managing residential blocks the burden of collecting and maintaining information about their individual tenants' disabilities?
Yes, I think there was concern expressed in the project group about the hazards of doing that, because you could be presenting to the Fire and Rescue Service information that was inaccurate and would therefore divert firefighters to flats in which there weren't disabled people, but the PEEP in the premises information box might imply that there, or would imply that there were.
With the views expressed in this letter that you've read, so far as you've read it, and those I've read out to you, particularly discussed with civil servants at the DCLG at the time?
the DCLG were part of the project group, sir.
Indeed, and that's why I asked.
And indeed, I just cut across you, sir. Do you want to finish?
Well, I was just asking you, were the views that I've read out to you actually discussed, do you recall?
Well, they absolutely were. And in fact, at the project group meeting in which we took these points along and said, let's discuss these, but ultimately we'll need a steer on this, there was representation from both DCLG and the Chief Fire Officers Association, incidentally.
And with whom at the DCLG did you discuss this point?
Those who represented the DCLG on the reference group.
Who was that, please?
Is that confidential information, or should that be revealed, Chairman?
I wouldn't have thought it was confidential.
No, that's okay. It's just I can remember some of the people in the project group.
Yeah.
In fact, at the meeting in question, I could actually draw you a picture of the table and where they sat, but I can't remember everybody who was there. So I wondered if it was out of context to cite the names of particular people.
If you can remember
the ones that were there.
Yes.
So there was Peter Wise from the Inspectorate. There was Andy Cloak from the Chief Fire Officers Association. There was Louise Upton from DCLG. And the only reason I'm citing those is I'm picturing in my mind going round the table at the end of the table at which I sat. What I can't remember is who would have been further down the table. But I remember Peter Wise, Andy Cloak, Louise Upton. There was someone from LGID, and I can't remember who else was there.
Can you tell us the gist of their views or their responses?
Well, you can see the outcome of the meeting, sir, in what's written in the LGA guide.
Right. So the answer is it? The gist of their views was as seen in 79.9 that I've read aloud.
Yes, I mean, I remember, and I think it would be inappropriate to possibly say who said what, because this is quite a long time ago, but I think I remember who said, how would you keep this information up to date? In some ways, you're better giving no information than giving misleading information and taking firefighters to flats possibly above the fire where there isn't a disabled person. The practicalities of it are very difficult. And the view was that the important thing was to make sure the compartmentation was right so that stay put was safe for everybody. There then remained the much more common issue, which I've referred to several times, of disabled people who have a fire in their own flat, which was, if anything, well, not just if anything, was much more of our concern. And this comes back to what I said was a very salient question asked by the chairman: what do you do about a disabled person who has a fire in their own flat? And the answer is, and I'm not going to go through all the things you can do, but there's a massive amount you can do and should do. And the view was that was a matter for community fire safety, not legislative fire safety.
Now, were the views expressed in this letter, so far as I've read them to you, taught to fire risk assessors on your LGA guide training courses in 2012 and 2013, do you remember?
I can't remember whether we would have got, you see, blocks of flats, I come back to the fact blocks of flats were not high profile. And so I could disclose the PowerPoint slide presentation, if you wish, from some of these courses, probably, because I know it dealt with disabled evacuation, and it dealt with it very robustly in terms of commercial premises. And by robustly, we were very intent on dispelling the myth that you can leave people in a commercial building for the fire and rescue service. And I do know that every examination paper on that course, every examination paper had a question on disabled evacuation. I can, won't take up your time with telling you what the sort of questions were unless you want to know. But
No, and what about your fire risk assessment courses that you ran in those years, 2012, 2013, with the views set out in this draft letter taught to candidates on those courses?
I come back to what I just said, sir. We probably never really focused on blocks of flats because the vast majority of those attending courses were interested in non-domestic premises. So there was quite a lot of discussion about disabled evacuation, about considering all different types of disabilities, the concept of refuges, communications in refuges, etc., assistance for disabled people, how you can provide it. But it was, as far as I can recall on those courses, it was all related, in all honesty, to commercial premises.
Now, in your role as chairman of the FIA, do you remember...
I'm not chairman of the FIA, sir.
No, but do you remember attending a meeting on the 9th of March 2012 where a decision was made that somebody called Martin Duggan should write to the IFSM, the Institute of Fire Safety Managers, to make it clear that the FIA's council's view was that PEEPs weren't required in general needs housing and that the FRA council could not support another event under an FIA banner where the contrary view was expressed? Do you remember that?
I don't, but I was... what I'm chairman of, sir, is the Fire Risk Assessment Council of the FIA.
Right.
And what I do recall was dealing with complaints from members after a seminar in which views were expressed that were, in the mind of those complaining, contrary to the understanding of the sector. And
Right.
Martin may have responded because of those complaints.
I see. Do you remember him doing so?
No, not off the top of my head, no.
Now, let's look at the final version of the of the Elspeth, the letter sent to Elspeth Grant in response to hers of the 23rd of August 2011. This is at CLG 1004932. We looked at the draft in some detail.
Yes.
Now, this is the final version, which is rather different. It's undated, unfortunately, but it comes from Caroline Bosdet at the
Right.
LGA, who, as you've told us, was head of the reference group. Just casting your eye down what's on the screen, do you recall whether you or your company had a hand in drafting it?
I would very much doubt that we would, but given that I have only vague recollection of this whole episode, I couldn't say one way or the other, but I would have thought, in the circumstances, we would have sent the draft letter to LGA. I mean, that was the purpose of drafting it, I imagine. And the LGA then, as it said, consulted with members of the project group and DCLG, and that they then produced their own version. But I'm surmising as to what is likely to have happened, sir.
Very well, that's helpful. Now, let's just note the second paragraph, where the author says, I've ensured that careful consideration has been given to the points you've made in your letter. This included, first bullet, seeking clarification from the original drafting team, CS Todd and Associates, appointed as expert consultants in the field of fire safety. Second bullet, consulting with members of the project group, including key officers from the Department for Communities and Local Government, DCLG, who funded the production of the guidance. And then if we turn to page 1, paragraph 4 at the very bottom, it says, paragraph 4, it says the development of the guidance was overseen by a stakeholder reference group, the composition of which is listed on page 9 of the guidance.
Yes.
A significant breadth of interest and expertise was represented on the reference group. The reference group signed off the guidance at its final meeting on 1st July 2011. The process of developing the guidance involved extensive public consultation through the LG Group website, which was widely publicised. In addition, several roadshows were held to canvass views on what should be included in the guidance, and on the proposed content. A project group was responsible for managing the consultation responses through the wider reference group of major stakeholders.
Yes.
And I think you've disclosed the lists of attendees, and we can look at those. Let's have those. CTA 6021, 6022 and 6023. if we can just have a look at each of those in turn. 6 zeros, 21, 22 and 23. Looking at the first of those, this is the delegate booking form for the meeting, 11th of May 2011. I think this is the road.
This is one of the road shows,
Yes.
sir. I'm not sure if it's relevant, but more people turned up at the road shows than had actually pre-booked, because often people phoned us and said, could we come along? So,
Right.
so that would not be necessarily all the attendees, but those that pre-booked.
Right. And if we look at just looking down the list there, we don't see, I don't think, help me, any specialists in disability evacuation or stakeholders representing residents with disabilities.
Is there a second page, sir?
There is. And if we can go to the second page, we'll see the second page. Same question again. There's a third page too, but long list of people. And my point is really a simple one, and I want to ask you about. Do you remember seeing anybody on that list, all the other lists, of attendees at these roadshows who were specialists in disability evacuation or stakeholders representing residents with disabilities?
I wouldn't remember who were attendees, sir. I mean, one of the roadshows had over 100 people. I think 80 booked and over 100 attended. So I wouldn't know who's there and who wasn't.
Can we go back to the letter then, please, at CLG 100049332? CLG 100049332.
Oh, one moment, sir. You couldn't just go back to the bottom of that, could you?
Yes, CTA 6021, please, page 1.
Is Lambeth Living, do they not specialise in housing for vulnerable people? I may be wrong.
Lambeth Living. Where do we see that, please?
I saw two people from Lambeth Living.
Page 2.
Page 2.
They may just be a housing association. It's just I happened to see the name of Tony Upfold, who I knew, and I dealt with him over some problems in sheltered housing. But they may just be the organisation that managed what was the council stock in Lambeth. I'm not sure. I know they did have specialised housing, as I recall.
Can we then get back to the final version of the letter as sent to Elspeth Grant, CLG 100049332?
Yes.
And can we go to page 1, penultimate and last paragraphs on that page, and then we'll go over the page.
Yes.
I've read you the penultimate paragraph. The last paragraph says, while the project group did not receive your comments at the consultation stage, there was considerable feedback on the issue of fire safety of people with disabilities and the vulnerable living in flats with within a purpose-built block, and the extent to which the guidance should and could address this. This was one of a small number of contentious issues that was specifically highlighted to the wider stakeholder reference group, and I can reassure you that the particular needs of people with disabilities and vulnerable people have been taken into account throughout the guidance. There were no practical solutions offered to address the issue of evacuation of people with disabilities from purpose-built blocks of flats. First, did the reference group itself contain any disability specialists or any representatives of organisations representing disabled persons?
Not that I recall. The project group didn't. The reference group was a much wider group, and I can't remember who was on it. But I know the project group didn't.
Right. Why did the project group not?
That would be a matter you'd have to put to LGID. We didn't choose the members of the project group. We were given them, as it were.
I understand that, but do you have any insight you can offer us as to why?
None whatsoever.
Right. Do you know whether the consultation actually consulted with any disability experts or representatives of that section of society?
I can't recall. I know we invited comment from as wide a group as a group of members of the public as we possibly could by advertisements in fire and housing magazines. We certainly invited comment right from the start from anybody who wanted to comment. And as I recall, the invitation went out to through Inside Housing and a number of fire journals, I think, who were kind enough to put in our appeal, as it were, for comment as to what the guide should cover. So there was a very wide consultation, but sitting here, I can't tell you whether any specialist groups concerned with disability were consulted.
Right. I mean, do you remember whether, since it had become such a contentious issue that was specifically highlighted to the wider stakeholder reference group, any thought was given by anybody you know or by yourself to making sure that there was somebody on the wider stakeholder reference group who was a specialist in disability?
Well, membership of the reference group was beyond our gift. And at the stage at which we flagged it up as a contentious issue on which we needed a steer, at that stage the reference group was already well established and was about to finish its job, as it were. Similarly, the project group.
Did anybody on the reference group or the wider group, sorry, the project group or the wider reference group, or yourselves, take any legal advice about whether you or they ought to be consulting such persons, given the potentially discriminatory nature of the approach that Ms. Grant had highlighted in her 23rd of August 2011 letter?
Do you mean before the guide was published?
Yes.
Or after?
Well, at any stage.
At any stage. The whole guide was read by government lawyers to check that it would comply with all legislation.
Right.
And in fact, comments came back from government lawyers, as I recall, on specific matters, such as I seem to recall government lawyers had a view on leaseholder doors and whether leaseholders could really be Article 5.3 persons. So the whole document was scrutinised by government lawyers.
Right. Do you remember, without telling me what the content of the advice was, but do you remember as a fact whether once Elspeth Grant had raised the legal challenge based on the Equality Act and other pieces of guidance or legislation and community law, anybody within the government specifically gave legal advice on those questions?
That would really be beyond our knowledge. Our project was completed in July when the guide was published in July 2011. I can see here that LGID or LGA, whichever it was by then, consulted with DCLG. Whether DCLG internally consulted with lawyers or who they consulted with, they wouldn't necessarily have told us, and I certainly don't know.
Okay. Now, would you mind just reading the rest of this letter?
Of course.
Yourself, because I've got a general question. You've read the first page, I think, completely. Would you read the rest of it?
No, I hadn't finished the first. Sorry, the page that's on the screen at the moment I haven't read.
Yes, we're at the top. No, exactly. That's what I'd just like you to finish reading.
Certainly, sir. I think I would just wish to draw attention to the last sentence of the first paragraph, and that's absolutely true. No one had any practical solutions. Lots of people, to use the modern idiom, talk about disabled evacuation, but when you ask them to walk the walk and ask what is it you would like us to do, they have no answers.
Well, since you've picked that up,
yes,
let me ask you a question about it. You say, or it says, there were no practical solutions offered. Had you or the project group actually asked any stakeholders for any, quotes, practical solutions, unquotes?
No, but one or two people raised the subject of disabled evacuation, but they didn't offer, they only offered fairly high-level comment about you'll need to make arrangements for people with disabilities, but nobody offered to tell us what these arrangements might be, and that remains quite a problem today, actually.
No, my point really is that no one was actually asked, were they? In the consultation exercise, nobody was actually asked for practical solutions to overcome the perceived practical problem.
No, we invited comment as to whether the guide adequately addressed people with vulnerabilities. We asked that specific question.
Yes, but you didn't ask them the question.
Would you like to tell us how to organise a PEEP for disabled people?
Yes.
No, we didn't.
No.
Shall I finish reading?
Yes, please.
Yes, the wording's been changed. I doubt that we actually had a hand in that, but whether it was run by us or not, I can't say.
Now, you having read it down to the signature, Caroline Bosdet.
I haven't come to her signature yet, but
sorry, I thought
it may be just off the screen. Yes, it's just off the screen. Yeah, thank you.
Right. Now, I've shown you the draft.
Yes.
And I've shown you the as-sent response.
Yes.
And you've read them, I hope, thoroughly, and we can go back to them again if you like. But having read them, do you accept that the as-sent version of the letter makes no reference whatever to the perceived practical problems for landlords in gathering and maintaining the information on disabled residents? Instead, what it does is it focuses on the benefits of stay put and the scope of the FSO. Can you, and we can read that difference, can you explain why the LGA guide, the LGA didn't tell Elspeth Grant in its response that the underlying rationale for the LGA's guide's position on PEEPs was to avoid imposing disproportionate burdens on landlords?
I have no idea, sir.
Right.
That would be a matter for LGA and DCLG as was.
Right. Did you have any discussion within your practice or with the project board about whether to set up a consultation workshop with resident disability specialists to consider the consequences of the then draft advice?
Not as far as I can recall, sir.
Do you think that it might have been a shortcoming in the consultation process for the sector to reach a view about the practicality of not having PEEPs or the practicality of difficulties of having them in purpose-built blocks of flats without consulting disability specialists?
What I would say again is that we invited comment from as wide a group as we could possibly access. I've been in fire safety for 45 years, sir. It would be no exaggeration to say I cannot think of any guidance published ever that I've been involved with that was subject to such massive consultation. A British standard wouldn't go out, for example, to the public with 3 roadshows and have a couple of hundred people invited along to have their say. And we undertook our own consultation with colleagues in the sector. The LGID defined who was to be involved in the project group and the reference group. So we thought, and it'll be for the chairman to decide as to whether we were wrong, all of us, including government and LGA. We thought we had consulted as widely as we possibly could, and we went to great efforts to that end, sir.
Now, can I come back to your statement? I want to ask you 1 or 2 questions next about the project board and the reference group.
Yes, sir.
If we go to your statement, CTA 6012, please, at page 12. Let's look together at paragraph 55.
Yes.
You say there, in the 3rd line,
Yes.
at this stage, I would note that one of the areas identified was whether PEEPs would be appropriate for purpose-built blocks of flats. Our view was that PEEPs, in the sense that the term is normally used, whereby staff on premises assist with evacuation of disabled people, were not practicable. However, we referred the matter to the project board for advice and a decision on this. I can recall the discussions on the matter at the project board, including some of those present at the meeting in question. The consensus opinion of the project board was that the LGA guide should acknowledge that PEEPs were not practicable.
That's correct, sir. Yes.
Now, we've discussed and I think you remember people sitting around the table.
Some of them.
Some of them, yes. Do you remember, did the project board consider how PEEPs could be made to work in general needs housing? In other words, did anybody around the table actually turn their minds to how it might be made to work?
I think it was all part of the discussion. You see, PEEPs, as understood at the time, sir, were procedures that were adopted in buildings with staff. And I come back to the distinction between evacuation and rescue. Evacuation being a routine procedure, whereby if there's a fire, everybody in the building evacuates, whether there's, if you like, whether there's a need to or not. It's a simultaneous evacuation strategy. And in those buildings, you need PEEPs for disabled people and that's what you get. It's not an evacuation. I know I'm repeating what I said before, but I think this is really important, Chairman. In a block of flats, if disabled people are having to leave their flats, something is wrong, unless the fire's in their own flat. So there's something very wrong, and when there's something very wrong, it becomes a rescue, an abnormal situation, and that's, without being flippant, that's what the R in FRS is for rescue. So it's not really an evacuation, so the term is a misnomer. And furthermore, to deal with the chairman's question, which I keep coming back to, how do you deal with people who are disabled and have a fire in their own flat? One of the first things you do is put telecare-enabled smoke detection in throughout the flat. That's how can that be called a personal emergency evacuation plan? It's not. You sometimes give them fire retardant bedding because they may want to smoke in bed, and they should be as entitled to smoke in bed as you or I, sir. So if that's how they want to, if that's the lifestyle they want, you don't tell them you've got to stop smoking because you're disabled. You work around how the disabled person wants to live their life. And you give them fire retardant bedding, you give them fire retardant nightwear, sometimes you give them what's called a smoking apron, which I can explain if you need me to. And so you kind of work around their lifestyle. And the ultimate, when all else fails, and you're still not happy that you've protected this person against a fire in their own flat, you put in some form of suppression. And I've done that myself, tailor-making it for a disabled person in a block of flats with a chaotic lifestyle. And we said, we can't do enough for this person. They're still going to die from fire. They need a suppression system. You wouldn't call a suppression system a personal emergency evacuation plan. And so that was why I said early in my evidence, sir, that providing a PEEP for a disabled person to cater for a fire elsewhere in the block is putting a superficial scratch on fire safety for disabled people.
Well, Mr. Todd, just help me, because when I asked that question, I had in mind, let's assume, a disabled person, maybe who relies on crutches or
Yes.
walking frame or whatever,
Yes,
whose flat is affected by a fire in the kitchen,
yes,
which gets out of control.
yes,
So he or she has to leave the flat.
yes.
And there he or she is standing in the lobby
All right.
of a building such as Grenfell Tower
Yes,
on, let's say, the 17th floor
yes,
with a lot of steps.
yes.
What, if anything,
Can be done for them.
done for them?
Well, that comes back to the Fire Brigades Union's point that tell these people they can use the lift. Don't tell them they can't use the lift, because you're forcing them down, in your case, 17 flights of stairs, when every other resident in the block is perfectly free and able to use the lift.
I mean, that might argue for the conclusion that in that case, and each case will no doubt depend on its own facts, but in that case, somebody should have thought about it, and the personal evacuation plan would say, if nothing else, use the lift.
Yes, and that is why, sir, I said that a PEEP is a subset of something much more important, which I called a person-centred fire risk assessment.
Yeah.
Because the very salient point you've made, sir, is that there's a variety of disabilities. And we have to cater for the worst case scenario in which the person is bedridden. But you make a very good point. There's a range of abilities between fully able-bodied and someone who's bedridden. And the only way to deal with that is a tailor-made person-centred fire risk assessment. And from that might fall out a PEEP. It might fall out a PEEP, or a personal rescue emergency plan, by which I've penned the name more recently for it, PrEP, which I notice people have latched onto. But you tailor-make it. And it's important that you do that, sir. And we don't do it enough, because remember, 180 people have died in blocks of flats since Grenfell. and many of these will be older people. Fire is classist and ageist. It picks on old people, it picks on vulnerable people, it picks on poor people. And don't take this the wrong way, sir, but High Court judges and QCs don't die in fires. People who die in fires are those who are the most vulnerable in society and the most impoverished in society. And what we should be doing is making sure that we have arrangements that we look after all disabled people, and we don't just scratch the surface and say, if there's a fire elsewhere, friends and neighbours will get you out. There's masses you can do, sir. I mean, I mentioned telecare-enabled smoke alarms, but that's just for starters.
Well, I think I get the picture, and that's helpful. Thank you.
Good. I'm sorry if that was one of my longer answers, sir.
That's all right. I encouraged you.
Thank you.
Yes, Mr.
Now, do you remember whether at the project board the concerns of the Chief Fire Officers Association that we looked at earlier at HOM 402660, page 7, were noted?
I don't recall that, sir, but I wouldn't wish to do a disservice to CFOA as was. So if you tell me that they, well, you're not telling me they were, you're asking me the question. CFOA were on the project board, I know for a fact. But whether they, I can't remember them strongly disputing the consensus opinion, but we're going out now into the granular detail of discussions, and so right. I don't want to do them a disservice.
You don't recall, I think, is the answer.
I don't recall, sir, no.
Can we go to paragraph 78 of your statement, please?
Yes, sir.
CTA 6012, page 17. And you say there, you recollect very clearly
yes.
the subject of PEEPs being discussed at the project group. And then you go on to say this, the consensus opinion of the project group was that it should be acknowledged in the LGA guide that PEEPs were impracticable because of the difficulty of collating information and keeping it up to date. What were the practical difficulties in collating information and keeping it up to date about disability or vulnerability if the resident was willing to provide it?
Okay, so it's not so difficult in social housing, but remember, this guide, sir, is written for all blocks of flats. So can I give you the hypothetical situation of a block of flats, posh block of flats in West London, if I can put it that way, all leaseholders, and the leaseholders have bought the freehold, so there's now a residence management company running the block. So the residents are the owners, the managing agents, and the residents. So first of all is identification. So when one leaseholder sells their flat, it's not incumbent on them to tell the other residents that they've introduced a disabled person into the block. If they have introduced a disabled person into the block, you have the difficulty that this disabled person, if say I'm bedridden, I buy my flat in this block, and I kind of say to the other residents, hello, I'm disabled, sort me out a PEEP. How would they actually do that? Is the rhetorical question. So collecting information, and many leaseholders sublet, so you don't actually know who's in each flat. And so you've got the difficulty of identifying the disabled people. That's only half the problem, maybe only 40%, because you now have to keep it up to date. And how often do you need to review that, because it will become very rapidly out of date? And one of my own personal horrors, which I share with some colleagues in the Fire and Rescue Service, is that you have a fire in a block of flats, perhaps not in London, perhaps in Ipswich, and you open the PIB and it tells you that there is a bariatric person on the 12th floor and the fire's on the 5th floor, but the officer in charge wants more people to come out. A bariatric person, Chairman, is a minimum of 4 firefighters and a basket stretcher. So we're now committing 4 firefighters, many floors above a fire, which you would never want to do, because you're putting them at serious risk. Firefighters will always put themselves at risk if it's necessary to save life, always. But so they will go to the 12th floor, and you've lost 4 firefighters. In a Shire Counties brigade, that's probably half of your firefighting resources that you'll have in the first 10 minutes. And in the meantime, you find that this bariatric person was taken into hospital last week, or they moved out of the block 6 months ago. So you check it every 6 months. Okay, they moved out 5 months ago. And you've now diverted firefighters from a disabled person who does need assistance and from dealing with the fire. So the problem is keeping the information up to date. Now, as it happens, and I don't want to digress into this, sir, because you'll cut me off, I know, but for the past 18 months, Chairman, I've personally been working on a technological solution to this, so that firefighters can be presented with real-time information about disabled people who are actually there. And I have funding for that, not for my practice. We're doing this on we're not charging for this, but to fund a couple of trial installations. And we have funding from the Fire Industry Association, Scottish Government, the Scottish Fire and Rescue Service, British approvals for fire equipment. And it's underwritten by a company called ACO, who said, we believe this is really right, and we'll give you up to £10,000 if you can't get it from anyone else. And we are poised to run a trial installation, one in London, one in Edinburgh. And we're just forming a steering group on which there will be disability groups represented, to see if we can actually solve this problem once and for all and give firefighters real-time information that can be easily kept up to date. I'm not going to bore you with why, but they will actually have accurate information. But that, of course, is still, sir, for the purpose of rescue, because it is rescue that probably arises. Does that help, sir?
Well, it prompts another question.
All right.
Why could that not have been done or developed or investigated in 2011?
Probably because the technology wasn't around for time and attendance technology, as it's called.
Was it investigated?
No, it wasn't, sir.
Why is that?
Because no one thought of it, sir.
Was it the Grenfell Tower fire that prompted these thoughts, which have given rise to the project
absolutely.
that you've just described?
Absolutely.
So had the fire happened in 2015, the thinking would have started then, or 2013, the thinking would have started then.
How can I say, sir? It came to me. It came to me one day, and I decided to progress it in my own time as a little hobby, and I've been doing that for 18 months with funding from a lot of supportive people in the fire sector.
Did anybody consider carrying out an equality impact assessment on the guide at the time?
That wouldn't have been a matter for us. That would have been a matter for LGA or DCLG.
Indeed, it would. But my question is really whether
I can't tell you the answer to that, sir.
Answer. Right. Now, finally, can I come to the BS 9991 guidance, which is 2015?
Yes, sir.
This is at BSI 6059. Now, it's 2015, so it clearly postdates the completion of the guidance, as you can see from the top right-hand corner. Is it a standard, I think it is, isn't it, a standard applicable specifically to fire safety in the design, management and use of residential buildings?
Yes, it's for the design of new buildings.
Well, management and use.
After design, yes.
Indeed. And it's a code of practice. First question, did you have any role yourself in the formulation of this standard?
None at all.
None. Now, in recognising as a general principle that in some circumstances fire services will need to decide to evacuate a building, can we look at BSI, can we look at this document, page 15, and look together at 0.2.1, and it says general principles.
Yes.
The means of escape from a flat or a maisonette of limited height is relatively simple. With increasing height, more complex provisions are needed because emergency egress through upper windows becomes increasingly hazardous.
Yes.
The provisions for means of escape for flats and maisonettes are based on the assumptions that, and then there are 4 set out, B, there can be no reliance on external rescue, for example, a portable ladder, And then if you look at C, flat or maisonette will have a high degree of compartmentation and therefore will be a low probability of fire spread beyond the flat or maisonette of origin. So in most fires, simultaneous evacuation of the building is unlikely to be necessary.
Yes, sir.
And then if we go to page 20, oh, I'm sorry, I do apologise. I'm so sorry. Can we go back to page 15? There's a passage you should just pick up. I want to pick up with you. Under the note, it says, towards the bottom of your screen, whilst a simultaneous evacuation is normally unnecessary, CA1 regarding stay-put strategy, there will be some occasions where operational conditions are such that the fire and rescue service decide to evacuate the building. In these situations, the occupants of the building will need to use the common stair, sometimes whilst firefighting is in progress. As such, the measures in this British standard for the protection of common stairs are designed to ensure that they remain available for use over an extended period.
Yes, sir.
Now, if we then go, keeping that in mind, please, to page 20, at the bottom of the page, we can see there, effective management of fire safety can contribute to the protection of the building occupants in many ways. And then D, by being aware of the types of people in the building, such as disabled people, elderly people, children, pregnant women, etc., and any special risks or needs.
Yes.
And then if we go to page 33, paragraph 4.6, inclusive design is the heading of this section, and the second paragraph says special management procedures might be required where it is reasonably foreseeable that the proportion of disabled persons in a building will be relatively high. Recommendations for building management are given in section 9.
Yes.
And then underneath that you'll see that attention is drawn to the Equality Act 2010,
Yes.
which places a duty on all employers and service providers not to discriminate against disabled people.
Yes.
It is vital to ensure, it goes on, that when making plans for the fire safety and management of buildings, the requirements of disabled people are properly taken into account at all times.
Yes.
Now, then finally, or penultimately in this document, page 145, if we can go to that page, please, and look at the second paragraph below 54, there's a note 1. Do you see? It says, and this is underneath the heading, evacuation of disabled occupants or occupants that require assistance to escape. Note 1 in the second paragraph says, it is the responsibility of the premises management to assess the needs of all people to make a safe evacuation when formulating evacuation plans. An evacuation plan should not rely on the assistance of the fire and rescue service. This is an important factor that should be taken into account in the building design.
Yes.
Then finally, page 175, and I'm sorry to give you such a long shopping list.
No, I'm managing, sir.
It builds up to a question. On page 175, there is a heading, Management of Additional Needs and Disabilities.
Yes.
And there's a reference, Annex E, Informative and General. If you look at the second paragraph, information for disabled people needs to be noted in fire action notices and in the fire management plan. Assumptions cannot be made about the willingness of individuals to remain in their flats even where a stay-put strategy is in place. It is also possible that some residents will not be inside their own dwelling at the time a fire occurs. They might, for example, be in the process of using lifts or stairs to reach their home, visiting a neighbour, or in a common area such as terrace or communal garden, in which case returning to their flat might not be appropriate or possible.
Yes.
And then in the last two paragraphs under that, the UK has an ageing society with increasing levels of independence into later years, and there are therefore many people living in standard residential accommodation who have a range of impairments which could affect their ability to evacuate or follow procedures. Fire safety management needs to take into account the full range of people who might use the premises, paying particular attention to the needs of disabled people with permanent or temporary impairment.
Yes.
And then E2 deals with people with mobility impairments, etc. And it goes on in that vein. And one can cover the next 2 pages, if one looks at the next 2 pages, scrolling down to page 176, with different impairments, cognitive and learning, hearing,
Yes.
vision, dogs, etc. Now, I've shown you a lot of that, probably not all of it that's relevant to this question, but in the light of what I've just shown you in this British Standard of 2015, did anybody, you included, ever suggest a reconsideration of the content of paragraphs 79.9 to 79.11 of the LGA guide?
I don't recall. I don't recall anyone suggesting any revision of the LGA guide. Not off the top of my head. Sir.
Right. Do you accept that a situation arose in and after 2015 whereby the LGA guide, at least on the subject of vulnerable occupants, was out of step with this British standard?
This is a design guide primarily for new buildings. This is about how you go about designing and managing new buildings, really. It's an alternative to approved document B.
The title, though, of the document is also about management and use.
Yes, it is.
Is it limited to new builds after 2015?
It's how it would be regarded, sir, as a new building design guide. People do design to it sometimes, and we come across that because they don't want to use approved document B. There will be stuff in here that is useful in general terms for existing buildings, no question. But I'm not sure anybody would have thought, well, now that BS 991 is published, do we need to revise the LGA guide? And certainly that would have been a matter for the LGA and or government departments.
And I don't think, I may be wrong, there's anything in this British standard which says that it's limited to new builds.
No, I think you'll find something probably in the scope that says it's primarily about new builds, but you might use it as guidance.
Similarly, would I be right in thinking that the LGA guide was not only about existing buildings?
You mean it was about new buildings?
Was it not?
No.
Only about existing?
No, it actually says that in it, sir.
Now, the first edition of this BSI, in fact, was published on the 31st of December 2011.
That's correct.
And it too contained at section 9 a section on evacuation of disabled occupants or those occupants who require assistance to escape. Do you remember that?
I vaguely remember that,
Right.
yes, sir.
Now, so when the LGA guide was put together in 2011 and then republished, I think, in May 2012, do you remember whether BSI 9991 in its 2011 iteration was considered at all?
Yeah, it wasn't revised in 2012. I think what they did was there was a paragraph in the 2011 that shouldn't have been there. It was a paragraph that we had in. The project group wanted it taken out, so we took it out and replaced it with another paragraph. But the LGID accidentally put the new paragraph in, but didn't take out the previous paragraph. So there were two paragraphs that directly conflicted, and they hadn't implemented what the project board asked us to do. It was about doors. So they corrected that in 2012.
Right. Subject to that, then, let me re-ask the question so that you answer my question. When the LGA guide was put together in 2011,
yes,
and then it having been put together in 2011, before the 31st of December 2011, when the first edition of this BSI came out, did anybody thereafter, when it came to revising it in the May of 2012, ask themselves, well, should we now say something to reflect or bring it in line with the newly published BSI 9991?
I'm sorry, this will probably appear as though I'm contradicting you, sir, but it wasn't revised. I thought I said that.
No, I appreciate that.
So it wasn't a revision.
No.
Had there been a revision, where a revision of a document is, so I'm teaching my granny to suck eggs, but in guidance parlance, you revise a document by sitting down with it and going through it clause by clause and saying, is it still up to date? Do we want a revision? There was no revision. I think that's important to understand.
That probably answers my question.
But
when the LGI guide was republished
yes,
in May 2012, not revised, but republished, was any thought given to revising it to take into account what the recently published first version of this BSI had said on the subjects I've shown you?
Again, that would be a question for LGA, but my answer would be not as far as I'm aware.
Very good. Thank you very much. Now, Mr. Todd, I've come to the end of my prepared questions, you'll be pleased to hear. It's customarily at this point to take a shortish break to see whether there are any follow-up questions that I need to ask you from my own side or from the core participants.
Of course, sir.
Outside this building, or even in it. So we're going to take a short break now, Mr. Chairman, if we may.
Yes, well, Mr. Todd, as Mr. Millett has indicated, we need to take a break now. And indeed, I think it's time we had a break during the afternoon anyway. So we'll stop until 25 to 4. And then when you come back, we'll see if there are any more questions for you.
That's fine, sir.
All
Thank
right?
you very much.
Thank you very much. We'd like to go with the usher, please. Mr. Millett, we're going to have slightly less than 15 minutes, so if you need a bit more time, just let the usher know.
Yes, very good, Mr. Chairman. Thank you.
Yes, would you ask Mr. Todd to come back in, please? Right, yes, please, Mr. Todd, take a seat. Well, now we'll see if there are any more questions for you.
Thank you, sir.
Mr. Millett.
Yes. Mr. Chairman, there are no further questions for this witness, having considered them carefully. But the questions that have been put to us may be very pertinent questions for others coming later in this inquiry.
Right. Very well. Thank you very much.
So, Mr. Todd, it remains for me, on behalf of my team, to thank you very much indeed for coming here and giving us your opinions in oral evidence. We're very grateful to you. So thank you very much indeed.
Thank you. Chairman, can I just wish you, your panel and the legal team well for the rest of the inquiry. Can I just express my condolences as well to those who lost loved ones at Grenfell Tower and assure them that virtually no week goes by, but many of us are involved in initiatives and committees and activities to try and prevent it happening again.
Yeah. Well, thank you very much, Mr. Todd. It's right that before you leave, I should thank you very much on behalf of all three members of the panel and indeed the inquiry as a whole for all the time and effort that you've devoted to our work, because it's not just a case of coming here for actually rather longer than I think you were originally led to believe, but to give your evidence orally. But you've produced reports for us, and I'm sure that a lot of time and trouble has gone into that part of your work as well. And we are extremely grateful for your help in all these different respects. So thank you very much indeed, and it's been a pleasure to hear from you. Thank you.
You're more than welcome, sir, and I hope it's been of some help.
Yes, certainly. Thank you very much indeed.
Thank you. Goodbye, sir.
Goodbye. Thank you, Mr. Millett. Now, we have another witness waiting, don't we?
We do.
But we need to rise for a couple of minutes just to make the appropriate arrangements.
Yes, please, Mr. Chairman. It'll be Miss Beryl Menzies who'll be taken by Miss Rose Grogan for
Yes.
for the rest of the afternoon.
Well, we'll rise now, and you can invite the usher to come and fetch us when you're ready, or when Miss Grogan is ready, at least. Right. Thank you very much. Yes, Miss Grogan. Now you have another witness for us.
Yes, we do. We have Ms. Beryl Menzies.
Thank you. Good afternoon, Ms. Menzies.
Good afternoon.
I gather you're going to make the affirmation.
I am.
The words are there on the screen. Would you care to read them out, please?
I do solemnly, sincerely and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. Do sit down and make yourself comfortable. Before we start, may I just apologise for keeping you hanging around for some time.
No problem.
We don't always quite manage to run to the timetable, so I apologise for that.
No problem.
Right. Yes, Ms. Grogan.
Thank you. Good afternoon, Ms. Menzies. Thank you very much for coming to give evidence today and for assisting the inquiry again with its work. I'm going to be asking you questions today about your supplementary expert report, which was prepared for Module 3 of Phase 2 of this inquiry, covering the building control body's assessment of the smoke control system. If you don't understand any of my questions, please ask me to repeat them or to put them in a different way. And also please keep your voice up so that the transcriber can hear you. Can we go first to BMER 607? This is the supplementary report you've produced for the inquiry dated 20th of April 2021,
Yes.
and it covers the smoke control installation that formed part of the building regulations application associated with the refurbishment of Grenfell Tower. Could we go to page 5 of that report, please? And here at paragraph 10, you explain, which is just at the bottom, that this report should be read in conjunction with your main report on the application for building regulations approval in relation to the Grenfell Tower refurbishment as amended in April 2020. And for the transcript, the reference is BMER 604, plus that report's appendix, BMER 605, and errata sheet, BMER 606. Can I just now take you to the last page of this document, which is page 71. We see there a declaration and statement of truth and a signature. Is that your signature?
It is.
Can you please confirm that the facts set out in your supplementary report are true to the best of your knowledge and belief?
I confirm.
Have you provided this report in the same way as you would have provided a report to the court?
Yes.
And does your report represent your true and complete professional opinion on the matters addressed within it?
It does.
When asking questions today, I may refer to this supplementary report as your report. And if we need to go to your first report prepared for Module 1, I will make that clear.
Okay.
I'd like to start with some questions about your qualifications and background. You were asked about these in Module 1, so we can take this reasonably swiftly. But just as a reminder, if we could go to page 3 of this document. We can see that here you've set out your professional qualifications and experience. And starting with your professional qualifications, you are a fellow of the Chartered Association of Building Engineers.
Yes.
And you told us in Module 1 that you've been a fellow of the CAB since it became chartered about 4 years ago.
Yes.
You were president of the Association of Building Engineers between May 2009 and May 2010.
Yes.
And you're also a member of the Royal Institution of Chartered Surveyors.
Correct.
Going on to your experience, we see just at the bottom of that page, so from the bottom working back up, your first role in the industry was within the Greater London Council in the Buildings Regulation Division between 1973 and 1985.
Yes.
After that, you moved to the London Borough of Tower Hamlets and became a chief engineer, implementing the building regulations and the London Building Acts, with responsibility for specialist officers dealing with innovative new buildings under construction.
Correct.
And since 1991, you've been an independent fire consultant and you are director of Menzies Partners Limited.
Correct.
Can you just remind us what it is that Menzies Partners does?
We are building surveyors and fire safety consultants.
Moving on to the next page, that's page 4. Can you confirm that you have previously been a member of the review panel of the Building Regulations Advisory Committee for approved document B?
Yes.
And can you confirm that you're currently a member of the Building Control Performance Standards Advisory Group of the BRAC?
I am. It hasn't met for some considerable time, but as far as I'm aware, it still exists.
And can you briefly outline your experience with smoke control systems, first as working on the building control side at Tower Hamlets and before, and then as an independent consultant?
My experience relates to many new developments within the Docklands area of Tower Hamlets, where we looked at pressurisation systems and other smoke control systems. Or more of late, I was a technical advisor to Tower Hamlets in respect of very tall residential blocks and their smoke control systems. I also visited North America in the 1980s to look at their forms of smoke control, mostly pressurisation, where it was more common at the time than it was in this country.
And do you have experience of refurbishment projects of the nature of Grenfell Tower or similar?
No, I don't. It was mostly new build. Refurbishment of such systems is not common in that buildings of that age didn't normally have smoke control systems that were mechanical in part.
Moving on to the relevant legislation, regulations and standards then, can we look at the section of your report beginning on page 8, please? So here and in the following pages, you've set out the relevant legislation and guidance, which includes the pre-refurbishment guidance, the guidance in approved document B, relevant British standards and the guidance provided by the Smoke Control Association. And in relation to approved document B, if we go to page 10, please, paragraphs 51 and 52, you say there that ADB set out that the aim of a smoke control measures for escape was to ventilate the smoke that will pass through a flat entrance door when the occupants escape, and that it recommended that the common lobby was ventilated to control smoke and so protect the common stairs. The ventilation was in addition to the recommended fire-resistant self-closing doors to a flat entrance and the common stair. And then paragraph 52, recommendations for natural and mechanical ventilation were given, stating that mechanical ventilation may be provided to the stair and or corridor/lobby to protect the stairs, and that guidance on the design of smoke systems using pressure differentials is available in BSEN 1201-6, 2005. And we know, as you've just mentioned, that Grenfell Tower had a smoke control system installed when it was first constructed. Can you explain how the building regulations and guidance in approved document B would apply to a refurbishment project where there was an original smoke control system already in place?
As with any refurbishment of an existing building, the legislation is set out that the situation should be made no worse. There is no retrospective legislation that requires a building to be brought up to current building standards, in as much as the building control standards refer to various forms of legislation. It would be any upgrade, shall we say, would be dealt with under the Regulatory Reform Fire Safety Order. For an assessment to say that, if it did say that the system was not fit for purpose for the use it was being put to in the particular occupied building.
And we can look at the non-worsening principle if we go to CLG 30019897, page 6. That's the building regulations there. Mm-hmm. If we go over the page, which is regulation, so onto page 7. We see there regulation 4, subparagraph 3, which is at the bottom of the page. It says building work shall be carried out so that after it has been completed, A, any building which is extended or to which a material alteration is made, or B, any building in or in connection with a controlled service fitting is provided, extended or materially altered, or any controlled service or fitting complies with the applicable requirements of Schedule 1, or where it did not comply with any such requirement is no more unsatisfactory in relation to that requirement than before the work was carried out.
Yes,
And that reflects the explanation you've just given us.
I hope, yes.
And so in simple terms, the no more unsatisfactory position, so the second option there, that's often referred to as the non-worsening principle.
Yes, if the works you were looking at, the situation we're looking at, did not comply with current standards, there was no means of going back and making it comply. It just had to be made no worse. Even if it complied at the time but was not up to current standards, or it didn't actually comply at the time, and for some reason it came into existence.
It's rather an imprecise criterion, that, isn't it? No more unsatisfactory. Has it given rise to difficulties of interpretation?
Yes, in as much as it's down to the individual to interpret it. You would have to establish what the situation was and then look at the proposals to see if the end result was any worse than existing.
It's a comparison of the practical functioning, is it, that one's looking at?
It's what the existing situation achieves. In very simple terms, if it achieved 4A changes and they were proposing 3,
That
then
would be worse.
that would be worse, yes.
Yes, thank you. All right.
Following on from that, is it right that non-worsening relates to the functional requirements of Schedule 1? So when you look at whether or not something is no worse, it's no worse in terms of satisfying B1 or B5?
The no worse situation would be the functional requirements requires reasonable means of escape under B1. If the existing situation provided reasonable escape, then you couldn't make it any less a standard than existed. If it didn't provide reasonable escape, in your opinion, but existed, you still could not require an upgrading of it. But you could tell the fire brigade that they might want to go and look at it under the RRO.
And in practice, how would a building control body go about considering if each of the functional requirements was either met or not made any worse?
It would be a case of hopefully looking at their records. Unfortunately, in this case, it wasn't possible. Or getting details provided by the applicant to indicate what the existing situation was. If necessary, go visiting the premises itself.
At paragraphs 43 and 45 of your report, which is on page 9 of BMER 607, you refer there to the guidance at the time the original Grenfell Tower system was installed.
Yes.
And if we go to those paragraphs, we see you say there, in the absence of information regarding what was originally approved, in my opinion, it would have been good practice for the BCB to refer to the guidance applicable at the time of the construction of Grenfell Tower. And paragraph 44, you say, whilst a review of CP3 would not have provided information regarding the Grenfell Tower smoke control system, it would have given an understanding of the fire safety protocol at the time of construction and would have assisted the BCB in ascertaining if the initial refurbishment proposal was a material alteration. And where the BCB control was limited to ensuring that the existing situation was made no worse, or if it was building work that should be regarded as requiring compliance, full or part, with the applicable standards current at the time of the application. Can you explain how a building control authority would approach a situation where an existing system was not in accordance with the guidance in place at the time it was installed?
Initially, I would suggest they would ask the person carrying out the works to provide any information they had on the building. One would expect somebody who owns a building to have some background to that building. If that wasn't available, ask for details of existing layouts, etc., or go down to the site and have a look and ask them to demonstrate what was there and to show what the layout was, etc. It's difficult, which is why records should always be kept to do so, but it's down to the person carrying out the works to provide that information to the building control body.
And the inquiry's heard evidence that the existing system at Grenfell Tower had been malfunctioning or had broken down well ahead of the refurbishment. Would you expect a building control body to carry out a non-worsening assessment as against the existing system in a fully functioning state, or in its state as it was at the time, so broken down or malfunctioning?
You would assess it against the system working, or how you would believe it would work. The malfunctioning aspect was not a building regs matter, it was for the RRO.
And presumably in a building like Grenfell Tower, you would be able to assess the extraction rate from a single lobby by reference to the size of the shafts and the capacity of the fans, insofar as there were fans working on the system. Is that right?
An assessment could be made by a competent engineer. The issue then comes to the leakage from the building. In an existing building, is always difficult.
Yeah.
No matter how much you survey a building, you won't know every crack, void, etc. that does exist. So the proof would be actually running the system. But if it wasn't functioning,
Yeah.
that's where the difficulty comes. So assume the worst and take it that they need to. My approach would be that if you can't prove what's there, then show me something that is adequate in what you're proposing.
But you could presumably do, I won't call it a hypothetical calculation, but you could do a calculation based on the configuration of the building and such information as you have about the plant incorporated within the system.
You could, but it wouldn't necessarily, because of the unknown leakage factors.
Right.
It would give an indication, but may not be the actual result.
You'd get a perfect figure, which wouldn't actually allow for the leakage into the system from...
Not necessarily,
Yeah,
yes.
right, I see. Thank you. Yes, sorry.
We will come back to this in more detail, but you said your approach would be that if you can't prove what's there, then show me something that is adequate in what you're proposing. Is that in the context of non-worsening, or would you in those circumstances, or we should say would a reasonable building control body in those circumstances say you have to therefore comply with the functional requirements of the building regulations as they are now?
I was always trained to assume control until somebody proves that I don't have control as a building control officer in the interest of public safety. Therefore, if they can't show me what they have, I can't say it's not a worsening or it is a worsening. So I would take the safe route, if you like, and ask them to prove it, or to, in their proposals, show me something that was adequate in replacement for that system as it existed.
And adequate in relation to the functional requirements, or adequate in relation to something else?
It's always in relation to the functional requirements. Those functional requirements are assisted, supported by current guidance, which is where your reference point would be. If they didn't want to adhere to current guidance, then we would ask them to employ an engineer to do a fire engineering assessment, a fire engineer proposal, and that would then be reviewed in that context.
If we could go to Dr. Lane's Phase 2 report, which is BLARP2, 5035 at page 44. So this is Dr. Lane's smoke control report, and here she concludes that the original smoke control system did not comply with the recommendations of CP3 1971, and the reference for the transcript is 3.3.28 to 3.3.4. At paragraphs 3.3.29 to 3.3.31 and at 3.34, she states that in natural ventilation mode, the aggregate area of the smoke shafts on each side of the lobby was 0.48 metres squared. The aggregate area of the dampers on each side of the lobby was 0.28 metres squared. These values are both significantly lower than the equivalent free area recommended by CP3 1971 of 1.5 metres squares when automatically opening. And then at the bottom you see there, she says, therefore the system did not comply with the requirements of CP3 1971 due to the aggregate area of the dampers being lower than the equivalent free area recommended of 1.5 metres squared when automatically opening. Do you agree with her assessment there?
I agree that the system did not comply with CP3, but it didn't have to. It was a system that was accepted under Section 34 of the London Building Acts Amendment Act 1939 and under Section 20 of that Act, which was permissible. The authority having control, the GLC, administered that legislation and accepted the proposal, which I would imagine was the result of a discussion between the developer, the Building Regulations Division and the Fire Service, and perhaps even the GLC scientific branch at the time. But from the few documents that I have seen, there was a system that was accepted that reflected what, well, I can't say it did reflect what was in existence because the paperwork wasn't there, but there is an indication there was a system that involved mechanical smoke control in Grenfell Tower on those two documents that the fire brigade, I think, provided eventually.
And just going back to the paragraphs we looked at in your report before, we don't need to pull them up, but you've said that in the absence of information regarding what was originally approved, so as you've just said, we don't know quite what was approved, but you say you know it would have been approved. It was reasonable and good practice for the BCB to refer to CP3. How in practice would that have worked, where you knew the system doesn't comply with CP3, but when looking at non-worsening, it would be reasonable to look at CP3?
This is where the problem arises. You would ask them to demonstrate, to prove what was there. If they couldn't, then it was either a case of, well, we're not going to accept any proposal from you, which would be totally unreasonable on part of a building control body, or ask them to provide a proposal. They wanted to do refurbishment works, they wanted to change the system, they couldn't maintain the existing system. In other words, they weren't prepared, for instance, to go and get 3D modelling of the existing fans and everything else and have one-off components, replacement components made, plus spares, which would be a very costly and unreasonable proposal anyway. But it was down to them to convince the building control body that what was there would be adequate in terms of B1 and B5. It couldn't be demonstrating no worsening because they couldn't prove what was there. But from an experience point of view, anything that was automatic would likely be better than a natural system in terms of the speed at which it would operate and the fact it was a mechanical extract as opposed to a natural extract, because the mechanical would be better in terms of dealing with downwinds, etc. It would be positive, and it would be activated as the fire brigade were en route. So it was working for people as they were escaping and protecting the building. Of course, it's all part of a system that is balanced by all the other aspects of Part B of the building regulations.
Moving on to the approach that was then taken by the parties involved in the refurbishment, staying in your report, so back to BMER 607, page 8 now. Paragraphs 35 to 38, you explain that in relation to the new smoke control system at Grenfell Tower, initially the BCB's control of the works as described in the full plans application was limited to ensuring that the proposals resulted in a smoke control installation on completion that was no worse / provided no less protection than it had existed prior to the alterations being undertaken. You then say the design of the proposed installation changed significantly as the design developed and it became a fully mechanical extract system. No information was provided regarding the working of the existing system, and as such it was not demonstrated that the various amended proposals would result in a no worse situation. And this, in your opinion, extended the control under the building regulations to require compliance with current guidance as far as was reasonable and practical to do so. And the BCB appears to have adopted this approach.
Yes.
So we're clear when you say guidance current at the time, does that mean at the time of the refurbishment?
Yes.
Is that just ADB, or would it include other guidance such as the Smoke Control Association guidance?
It would be to the person proposing the works to adopt the guidance. You should not cherry pick from multiple codes to make it suit your proposal, because it would make it work. But you can take aspects of different forms of guidance, because the guidance is published at different times, and more recent guidance may have better guidance than, say, ADB 2013. Subsequent 2015 guidance, 9991, for instance, more guidance, more technical guidance to assist people designing installations.
You say the BCB appears to have adopted that approach. On what basis did you reach that conclusion?
In as much as they asked for information regarding the existing system, they didn't appear, from what I've seen on the disclosures, they didn't appear to receive that information, and they then proceeded to review a proposal that developed over some considerable time and changed from what was originally proposed.
And what do you mean when you say a reasonable and practical extent of compliance?
I suppose in simple terms, it's getting as near to the recommended standard as possible.
And recommended standard being guidance or being B1 and B5?
Fulfilling the functional requirements under B1, B5, having reference to and regard to published guidance in the absence of a fully engineered proposal.
So would it be fair to summarise that as following the guidance as best you can, but always ultimately aiming to achieve compliance with the functional requirements?
In terms of B1, does it provide reasonable and adequate means of escape? B5, facilities to assist firefighters in fighting the fire.
Dr. Lane's view is that the parties involved in the design of the system and the submission to building control did not adopt a non-worsening approach, and therefore the only other option available to them was to identify an alternative design approach to comply with the functional requirements. The reference for that for the transcript is BLARP 2 5036, page 5, at paragraphs 10.2.11 to 10.2.13. Would you agree with that?
On the basis that they couldn't prove what the existing was, therefore they could not prove it was better or worse.
And in circumstances where it's not possible to comply with guidance, how would a designer demonstrate compliance with the functional requirements of the building regulations?
Presenting a scheme that would adopt criteria in terms of performance by reference to accepted guidance, a performance level in a code of some sort, or demonstrate it via modelling or CFD, computational fluid dynamics programming.
In his evidence, Mr. Humani of PSB described the approach ultimately adopted as a betterment exercise, and the reference for that is day 155, page 110, line 22. And we can see that in a different place in the transcript for day 155, page 24, line 14. just checking that that's the right reference. Yes, so he says there, sorry, it's line 19, not line 14. What happened was that Max Fordham reviewed the information that we provided them with to say you couldn't install a compliant system. It was impossible. And that therefore, in order to find a solution which entered to the spirit of the guidances, not compliant, we've put forward a suggestion of a system. This was not taken up. And then on to the next page, please. So page 25. What they then did was to take the volumetric flow rate that we had specified and put it forward as an improvement to the existing system, and that was how the project went forward. It was on developing improvement, not a design, and they did a document that they sent through for approval by building control, who approved the betterment. What do you understand the concept of an improvement or betterment exercise to be?
I've never heard the term betterment used in this context. An improvement over and above what was existing, I understand. Betterment is usually dealt with in terms of leases and dilapidations and the like, but it's in the dictionary and it just means better than before. Can't say any more than that, really.
Having heard the evidence, how do you understand that this betterment exercise relates to the two options we've discussed, so either non-worsening or compliance with modern standards?
It was a move towards the latter, in as much that it took a performance criteria, which was of a recognised standard, be it from a different approach, i.e. the pressurisation, depressurisation code, but it was a flow that was recognised in that document as being adequate to hold back smoke from the staircase during escape and during firefighting. So it was, and I agree, it was better, likely to be better than existed. So it was an improvement on the existing. But because of the approach that was taken, it couldn't be pointed to in any specific code as fully complying with that code. So it required judgment on the parts of the building control body to consider whether that was adequate in the circumstances.
And again, when you say adequate, you mean adequate with reference to B1 and B5?
Entirely, yes.
So would it be fair to say that your understanding of this betterment concept is that it's not some halfway house between non-worsening and full compliance with B1 and B5? It's a species of the latter?
Yes.
What kind of analysis would you expect a reasonably competent BCB to ask for to justify that kind of betterment proposal?
It would be calculations or modelling in the form of built models, computer models, or in CFD. But calculations would be acceptable. The issue with calculations, it doesn't give the designer 100% confidence because, particularly in an existing building, the day you turn it on and what you've done doesn't actually arrive, if you like, is not demonstrated, then it can be because you weren't aware of something and did not take it into consideration in your calculation. But it's a risk that is taken with safeguards, so building in extra leakage factors, etc., which is what was done in the small calculation, admittedly, that was done by PSB, which I'm not sure that building control ever saw.
We'll come on to that topic probably tomorrow. Different individuals giving factual evidence have referred to the design approach in different ways. So as we've discussed, Mr. Mani referred to it as betterment. Given what we've heard from the oral evidence and also your review of the underlying documentation, can you help us on whether you think that PSB and the BCB had a common understanding of the basis of the design?
From what I've seen as disclosures, there would appear to have been, but there is no documentation to substantiate my perceiving that to be the case.
So your assessment of what happened was that everybody was working towards compliance with modern standards?
Towards it in the context of an existing building and the limitations that imposed.
But at all times seeking compliance with B1 and B5?
Yes.
If we go now to page 68 of your report, at paragraph 290, you say there, the proposed design of the smoke extract installation incorporated the adoption of the recommended velocity of at least 2 metres per second at the open lobby stairwell door for the class of system appropriate for means of escape and firefighting in BSEN 12101-6, Class B. And you say, in my opinion, the adoption of this flow rate as a design principle was reasonable in the circumstances. However, whilst readings established the design flow was being attained, I've not seen any disclosure that indicates that the CB sought confirmation of, confirmed or witnessed the physical path of the air (smoke) movements away from the stair, and that there was no significant inflow from other leakage paths such as the fire flat. And if we go to page 51, so slightly earlier in your report, and paragraph 182, you say there's no specific explanation or justification for the adoption of the 2 metres per second within the technical submission. Can you explain why, in the absence of explanation or justification, you consider that the proposal of 2 metres per second velocity was nonetheless appropriate in the circumstances?
It was a well-recognised code, that is 12101-6 was a well-recognised code of achieving a high standard of safety to deter smoke spread. Everybody appeared to know it, but nobody actually wrote it down for the record, so to speak.
And was it acceptable to take that particular criterion from BSEN 12101-6 without explaining precisely why that was done, why other criteria weren't chosen, for example, in the technical submission?
On reflection, in the absence of records for future reference to, it was not, and building control should have said, why have you adopted this particular criteria? I think it was almost a familiarity and therefore an omission to record it. I can't think of any reason why it could not be recorded, but it just wasn't, as far as I can ascertain.
But the probability, I suspect, is the answer would have come back because we've taken it from the standard in question.
Yes, yeah.
That would have been acceptable to building control?
I believe it would, yes.
And how would building control know that the resulting design actually worked, and in what circumstances it actually worked, without that justification or explanation?
The only time you'll know it works is when you test it. And the offence under the building regulations, unless it's a procedural matter, is on site. So if it had shown not to have the 2 metre per second flow minimum, then it would have been a case, this doesn't comply. And then enforcement could have been taken. Enforcement action could have been taken.
In his evidence to the inquiry, Mr. Mane said that the new system's route to compliance was based on it generating a greater extract rate than the existing system. The existing system's extract rate had been calculated by Max Fordham on instruction from the TMO, and Mr. Mane's evidence was that they took the volumetric flow rate and put it forward as an improvement to the existing system, and that's how the project went forward. The reference for that, we don't need to go to it, is day 155, page 25, lines 1 to 7. Mr. Macross Smith of Max Fordham said on day 157, page 175, line 4, the building control came back and said, we don't think that you're adequately providing your proposal is an improvement. And they laid out what they would like to see in order to satisfy them that it was an improvement. And that the outcome was that they could go away and do either what they termed a hand calculation or CFD. And it was decided that the hand calculation would be the way that they would go. Just pausing there, you referred earlier in your evidence to calculations as being one way of demonstrating. Is that what you're referring to, a hand
Yes.
calculation? you've looked at that hand calculation. If we pull it up, it's MAX 402335 on page 2. And if we just zoom in on the top, so the middle section, to existing system, and then scroll up a little bit, we can see the rates there. So it has flow rate of existing system 1.1 to 1.2 meters cubed per second, and flow rate of proposed system 5 meters cubed per second. You've said in your report that you're unable to ascertain whether it was seen by the BCB, and you've mentioned that again just now. In those circumstances, are you able to assist us with whether the Max Fordham hand calculations represented a sufficiently reliable basis for comparison against the intended performance of the new system?
Would it result in it? No, I can't, because there's no description of the likely losses, leakage via the fabric, etc.
And if the Max Fordham document wasn't part of the review by the BCB, on what basis could they have approved the final scheme as being an improvement if they never saw this?
The proposal was to achieve a 2-metre flow. As to what was actually seen by the BCB, the disclosures, as far as I can recall, do not indicate that they saw any calculation. However, ultimately, they couldn't have stopped this proposal going forward. I know they said it was satisfactory. They couldn't have stopped the proposal going forward because they couldn't stop the work, so it was the testing that proved it would achieve the 2-metre flow. They said it would be satisfactory on the basis of it achieving that, as I understand it from the available documentation, on achieving that flow. Whether they said it would be satisfactory on the basis of the calculation, which they may or may not have seen, and they had several discussions that were not minuted. No notes are available. It may have been discussed there. Does that answer your question?
Yes, I think that helps. Mr. Hansen's evidence on day 154, page 117, lines 10 to 12, was that the path that they were proposing to fit a new extract system was the right path. What we needed to establish is what the extract rate should be. Is it correct to say that establishing the extract rate is a different approach from setting the open door velocity as a performance criterion of 2 meters a second? So the extract rate from the dampers in the lobby is different from the velocity, although there will be a link.
There's a link in the extract achieves the flow.
Does that statement that he wanted to establish the extract rate materially affect your view about the approach taken to achieve compliance?
No, but I don't really understand his question. Why he wanted to. It would all been part of the calculation. So it's almost a case of working backwards to achieve what size fan do I need to achieve that flow in that particular situation.
The existing system had a mechanical boost function which was operable by the fire brigade. Do you share Dr. Lane's view that this means that the existing system had both a means of escape and firefighting performance features?
Yes, it allowed the fire brigade on arrival to increase the extract by boosting it mechanically if they needed it, or as it was often used and is still often used after the event to get rid of the smoke.
And does that mean that both of these features required consideration during the refurbishment?
The purpose of the smoke control system was B1 for means of escape and B5 firefighting, so yes, it was a consideration.
And now we've heard the evidence regarding the comparison of extract rates. Does that in any way affect your view regarding whether it was appropriate to adopt the 2 meters per second velocity flow rate?
No, I think it was reasonable to adopt that in these circumstances.
And was it good enough to just look at overall extract rates, or would you have expected to see a more detailed analysis? being submitted to the BCB?
I think I'd have to say the BCB couldn't prove it would not work. It would have been better to have more analysis of the proposal, but there were so many unknowns in an existing building. If it didn't work when it was tested, then that would have been catastrophic for the people undertaking the work, because it would have had to have been changed, and that being cost, money, time, etc. So it was almost as if people were willing to take the risk of it not working, but on the basis of they've done some work by calculation to establish what they thought they would need to achieve that rate. So they put it to a specialist with experience at a level they thought would be adequate for them to design a system that would achieve that performance criteria.
Would I be right in thinking that if the primary, possibly not the sole, but if the primary purpose of the system is to stop smoke getting into the stairs, then provided you get the right airflow across the door from the stairwell into the lobby, the volumetric extract rate through the shafts is of secondary importance?
That's the way I would look at it, yes.
Yeah, right, thank you.
Thank you, Mr. Chairman. That's a convenient moment for us to
Oh, is
pause
it?
for the afternoon. I've reached the end of this topic and I'll be moving on
Yes.
to another one.
Right.
So,
Well, yes, that sounds like it is a convenient point. Ms. Menzies, we're going to stop there for the day. That means I'm afraid that I'm going to have to ask you to come back
That's
tomorrow.
fine.
But I suspect you factored that in
Yes.
to your arrangements. I hope so, anyway. So we'll resume, please, at 10 o'clock tomorrow. And as with all the other witnesses, I have to ask you not to discuss your evidence with anyone overnight, all right?
Certainly.
Good. Thank you very much. We'll look forward to seeing you again tomorrow. And
Thank you.
if you'd like to go to the usher, she'll look after you.
Thank you very much.
Well, thank you, Ms. Grogan. So we'll resume at 10 o'clock tomorrow and see where we go then.
yeah, thank
Good.
you.
Thank you very much. 10 o'clock tomorrow.